Welcome to the Rocky Mountain AI Interest Group. The following meeting, entitled Legal Aspects of AI, took place on November 13th, 2023, at the Atlas Building on the CU Boulder campus.
Our next speaker is Tamara Pester Schklar. She's a seasoned attorney specializing in trademark and copyright protection. She's the owner and founder of TMBTQ, a boutique firm focusing on IP law, as well as she is also the creator of an online class called LearnTrademarks.com that helps individuals learn about trademark protection. With over 2 decades of experience, she's become a trusted expert in registration and enforcement and defense of copyright and trademark rights. Over the past year, as generative AI has been more widely adopted, she's been working with clients with unique and interesting issues that arise with protecting the rights of creators who use AI as a tool to generate parts of their work. Please join me in welcoming Tamara.
Thank you, Dan, for the introduction. Can everyone hear me okay? All right. Well, it's great to be here. And I almost want to shift my entire presentation to address the issues that Michael and Jason raised about how law firms are so stodgy and resistant to change. I just want to say not all firms are like that. I did work at a large firm for a couple of years after law school. I've also worked as in-house counsel, and I've had a small firm for the last 15 years. And I just want to let you know, some attorneys, I'm also part of a group of about 600 law firm owners that get together quarterly to talk about, challenges with our practices and whatnot. And for small and growing firms, we definitely do embrace technology. And I believe that flat fee billing is going to be more widely adopted because I really think that the billable hour is dead. As people understand that AI and other technologies can be used, it helps to improve the efficiency of delivering legal services. But anyway, that's not the topic of what I was going to talk about. So I want to talk to you tonight about the challenges that creators face when trying to register copyrights in works that are created using AI. Oops, there we go. Dan already gave a little intro about me, and we don't have too much time, so I don't want to talk about myself too much. I want to talk, does everyone know what the different types of intellectual property are? The difference between a trademark, copyright? Kind of, not really. Okay, so I'll talk for just a minute or two about the different types of intellectual property and what a copyright is specifically, why securing copyright registration matters, and whether artificial intelligence is a tool or is it actually the author, which is really a question we've been grappling with because of my representation of Jason and his beautiful work, which is a small copy is over here that you can look at. We'll be delving into the specifics of our attempt at registering the copyright in that. Intellectual property, as most of you probably know, isn't something that you can touch or feel. It's not tangible. There are types of intellectual property that do require formal registration, like patents, and some that do not. It can provide a competitive advantage to your business and increase its value. It's an asset that can be transferred to a new owner. And if intellectual property rights are enforced, they can definitely give you a corner on a market. So intellectual property can be an invention, creative work. For trademarks, it's a symbol or word used in connection with particular products or services, designs. Oh, and by the way, the QR code on the bottom, if you scan that, some people have been requesting the specific documents related to Jason's case. The Copyright Office registration refusal and our request for reconsideration, their second refusal and our second request for reconsideration. So if you scan the QR code, you'll get it on our list, and we will release it to you when we release those documents to the public, which I think is later this week, right, Jason? Soon. So a copyright occurs in an original work of authorship. Usually this relates to a book or a movie, something else that is created by an author. So what actually is an author? According to the Copyright Act, human authorship is required. It will not register something that is produced by a machine or mechanical process. This is important, that operates randomly or automatically without creative input or intervention from a human. So the question we really grapple with is whether the work is one of human authorship, whether the traditional elements of authorship were conceived and executed by a human. Copyright gives the owner a bundle of rights that include the right to reproduce or copy the work, prepare derivative works, distribute it, or perform it publicly. The reason that copyright registration is important is because if you have a registered copyright with the US Copyright Office, you are entitled to statutory damages in cases of infringement. Statutory damages can range from $750 to over $30,000 per infringement. This amount, of course, can be lowered or raised by a judge if the infringement is deemed inadvertent or if there's factors that sort of mitigate it. For instance, there was a parent-teacher organization that used a copy of the Barefoot Contessa's recipe in a book that they put together and the parents sold as a fundraiser for the school. That was not really considered a serious infringement of copyright because the purpose was to benefit this organization. On the other hand, if someone is using an entire work and incorporating it into something that they're selling for profit, that would be willful infringement and they would be subject to the greater amount of damages. So as you know, artificial intelligence relates to the simulation of human intelligence. The definition of artificial is something that is made or produced by human beings rather than occurring naturally. So this really does focus on the human aspect of artificial intelligence. The Copyright Office has created this really existential question of who owns the copyright if AI helps to generate the work? Does the creator own it, or is the AI just creating it on its own? So now specifically in the case of Jason Allen, who by the way is right here in the front, he created this beautiful piece, Théâtre d'Opéra Spatial. In 2022, he won the Colorado State Fair. It became pretty controversial once people realized that he used Midjourney to help create the work. A bunch of articles about it, you can Google it. Jason's also spoken all around the world about it. We applied for copyright registration of this work in September of 2022. We paid the additional fee for it to be expedited because he was already aware of instances of people incorporating his work without giving him attribution or any payment for it. So we did apply in the expedited track. I think it's like an extra $700 or $800, and it is supposed to get you a response within 2 weeks. Well, we didn't hear from them in 2 weeks. We didn't hear from them in 4 weeks. We didn't even hear from them in 6 weeks. But finally, in December, they refused the registration. They determined that Jason actually didn't do anything. Their response talked about how all of the content within the deposit was attributable to AI, that he did not apparently paint, sketch, color, or otherwise fix any aspect of the deposit. However, they did offer that if we wanted to deposit the long list of prompts that he came up with to generate the work, that might be registrable, but we declined to do so because if we deposited all of the prompts, then they would be public record and anyone could reproduce them, which they have anyway, but we'll get to that. So the next month we filed our first request for reconsideration with a bunch of different reasons, both legal and public policy reasons why they were wrong and why both under case law and for public policy reasons, the Copyright Office should grant this registration. There's some case law that talks about really the minimum amount of human authorship that's required in order to grant copyright registration. It's really a very minimal amount. There are cases where originally the Copyright Office refused to register photographs because people, the photographer was not considered to be really taking any action, and he was using this, newfangled machine. But the Supreme Court deemed that that was enough to make it a registrable work, where the photographer was arranging the people, putting the subjects in a way that the light would hit them in a way, and otherwise creating the sort of from the images in his mind, making that into reality. We believe that the Copyright Office went outside the scope of what they were supposed to do, and also in violation of the Copyright Act, considered, made like a value judgment on whether this was something worth registering or not. They also went outside of the scope of the application and did their own research about, all these articles about Jason Allen's work. They also, are not supposed to consider how long it takes to create something, but rather whether or not there is any originality. They didn't do any of these things. We also talked about a lot of the public policy reasons, which I'll get to in a second too. Meanwhile, they had refused our registration. We submitted this request for reconsideration. And then a couple of months later, they came out with this new guidance where they call it their guidance on artificial intelligence, but it really still leaves a question. Under the new guidance, they are supposed to determine whoever gets the copyright application come into them at the Copyright Office, though that person determines whether the work is basically one of human authorship or whether the traditional elements of authorship were conceived and executed not by a human, but by a machine. In this guidance, I feel like they are contradicting their own, the Copyright Act and the sections where they are not supposed to make a judgment like that. They also really don't provide any clarification on what amount of work generated by AI versus created by a human makes it registrable or not, just leaving a lot of confusion. They did not like our request for reconsideration and made another refusal in June of 2023. Also just a little bit about Jason's process. He input over 624 prompts to generate the image. It was, a series of prompts, and I haven't seen them, but based on our conversations, it's a series of prompts that talk about, in general, what he wanted the image to look like, and then narrowing it down, focusing in on particular items and moving things around and how, changing the light and changing the shape of the heads and all kinds of things. It wasn't like he just pressed a button and this image came up. It was a give and take with Midjourney. So despite that, and despite the process that we described, the Copyright Office continued their refusal. They still didn't think it was registrable. They did, and after the image was generated, then Jason used Photoshop and Gigapixel AI to upscale the work. So the Copyright Office is now going to allow us to register the portion of the work that's upscaled and the portion of the modifications that he used Photoshop for, but still not with Midjourney. The Copyright Office doesn't think that Midjourney understands grammar, sentence structure, or words like human, but rather converts words and phrases into small pieces and thus generates the image. of course, we think the Copyright Office is wrong, and we filed another request for reconsideration this past July. We found, we cited some additional case law that wasn't included the first time, talking about ambivalence and antagonism towards AI, and that really shouldn't color the Copyright Office's consideration of this work. However, it seems that it did. We really, this really does pose an existential question about whether artificial intelligence is intelligent enough to create the work. We don't think so, but according to the Copyright Office, it may be. They make it seem like Midjourney created this by itself, even though if you look at the definition, again, of artificial, it is man-made, and therefore Midjourney can't just generate something without a human conceiving of it and putting it into being. They did send a final refusal a couple months ago. They still don't believe that Jason is considered the author of the Midjourney image, minimizing his contribution to merely inputting text prompts. They had some other interesting verbiage here about how human authored modifications, in other words, the part that he upscaled and used Photoshop for, might be protected by copyright, but the entire work cannot be. And yeah, that was their final refusal. I think that this Facebook post that Jason let me know about at the end of September really crystallizes the dilemma that we're facing. So another artist incorporated his entire image into her image and posted on Facebook saying, "They say that great artists steal, but as the IP never vested in Jason, no theft has occurred." And then there was like 600 comments about it. My favorite comment was this guy, Vladimir Gajic, who says, who emphasizes it takes countless hours and iterations to produce this. Artists who use AI, Photoshop, Gigapixel, everything produced by you could claim that everything produced by these tools is merely a product of a non-human entity and therefore can't be copyrighted. What about smart cameras? Will we ever own a photograph in the future? This is nonsense. This discussion is far from over. Just, summary of the challenges we're facing. And for creators, some best practices, including using watermarks, trying to input your own creative input into these works, even though we think it's already creative. Use some other tools other than AI programs. And I still believe it's worth attempting to register it. I think there is going to be a movement. Even though we're done at the Copyright Office level, we still have a lot of steps to go in federal court. There's a district court, there's a court of appeals, ultimately maybe all the way to the Supreme Court. But I think it really is a question that we will be grappling with. I'm just going to back up to my favorite slide. This discussion is far from over.